to $2,600 per candidate per election and $25,000 per election to parties themselves. On the phone with us is Chuck Hatfield, a Jefferson City attorney who has filed a lawsuit seeking to stop implementation of the new law. Good morning, Chuck.
Good morning, Jay. How are you?
Good. Why don't you give our listeners just a little background on this particular measure that was passed by the voters?
Sure. So the voters passed a constitutional amendment that makes some pretty significant changes to the way Missouri campaigns are funded. And I'll just skip right to the problem. I think the problem was this was a 9-page long amendment. The voters saw a 100-word summary, and it sounded pretty good. It sounded pretty enticing. I think there's a lot of support out there for limiting the amount of money that's given to candidates in politics. And certainly the Constitution allows the government to limit contributions directly to candidates. But what this measure does, it goes a little further, and it kind of picks winners and losers who are allowed to participate and who aren't. So it says that certain types of corporations may continue to contribute to political action committees, but other types of corporations are banned from doing that. And there are some other nuances to it. But I think the main problem is that the way it's drafted, it sort of allows some people to speak and not others. And that's kind of the concept that the First Amendment doesn't allow.
The voters overwhelmingly passed this resolution or this law, 70%, I think. And again, I think people are tired of the role that big money is playing in elections. We just heard that Eric Greitens spent almost $29 million on his election. Chris Koster, $25 million. And before this new law goes into effect, Eric Greitens has gotten $1.6 million, $1 million of that from David Humphreys of Joplin. And he's not even running for re-election for another 4 years. In fact, he hasn't even, been officially hasn't even become the governor. A lot of people see this as just buying officials. So why would we not want these limits in place? Well,
personally, I think limits are a great idea, and my clients who are suing over this law are not opposed to reasonable limits. And Jay, just to follow up on your thought, I think the U.S. Supreme Court has said that the government and the people, the voters, do have an interest in limiting how much money can be given directly to candidates. It looks like people are giving money because they want something in return. That's what the Supreme Court, in Latin calls quid pro quo corruption, or the appearance of corruption. And so, we can limit that, and in my opinion, we should limit the amount of contributions that are given directly to candidates. But the First Amendment is, kind of a tricky area, and we've seen that a lot with the discussions about Citizens United, that sort of thing, because it wants to protect us in our speech, but it also wants to allow us as a people, to limit corruption, as I was saying. So this amendment has some parts of it that are constitutional and that I think are probably pretty good public policy, but there are other aspects of it that unfortunately went too far and violated the Constitution.
Could you tell our listeners your lawsuit seeking to stop implementation of this law, if you had your way, what would the law look like at the end of the day? Would it be totally thrown out, or would you carve out certain portions that you feel violate the First Amendment?
Yeah, so let me be clear. We're asking for both. We're asking the federal court to carve out the portions that violate the First Amendment. As part of that analysis, we point out that the court may have to take out the entire amendment under Missouri law. But I think my clients would be okay with carving out the portions that offend the Constitution. So to answer your question, what that would leave us with would be limits on contributions. It would probably include a complete ban on all corporate or labor union contributions directly to candidates, which is something the federal law already does. That would be allowed, I think, if portions of our lawsuit succeeded. But all corporations that contribute to PACs, so it's a slightly different issue, all corporations would be allowed the same ability to participate. They wouldn't discriminate between them.
And just so it's clear, Chuck, your clients in this lawsuit are whom?
Well, so the Missouri Electric Co-ops And Jay, that's a great point. Right now, under the law, the Missouri Electric Cooperatives may not contribute to their own political action committee that they had set up and established to support candidates. Yet, Ameren UE can contribute to political action committees. They do the same thing. They have the same political interests. So I have the Missouri Electric Co-ops, a bank called Legends Bank. Banks are currently prohibited from contributing to PACs, while other corporations can do that. And then we have an individual former state senator named David Clint.
Chuck Hatfield, Jefferson City attorney, who has filed suit on behalf of his clients to stop implementation of the campaign contribution limit law. It is a big morass. It's something that's not going to be probably sorted out anytime soon, definitively. Thank you for joining us, Chuck.
Thanks, Jay. Have a good show.
Thank you. It's 8:11, 18 degrees. Jay Kanzler at KT.